Welcome to this in-depth explainer on how administrative bans and policy freezes can disrupt the path to U.S. citizenship for lawful permanent residents. In this video, we will break down what changes mean, how filing differs from adjudication, what an adjudication freeze looks like, when and how litigation can help, and how to build a strategic action plan. We will also include a disclaimer and provide quizzes to test your understanding. Let's begin. First, here is our roadmap. We will start with what changed and why it matters. Then we will clarify the difference between filing an application and the government adjudicating it. Next, we will examine what an adjudication freeze looks like. After that, we will explore legal options like a writ-of-mandamus. Then we will lay out a practical action plan, discuss timelines, risks, and costs, and close with key takeaways. Along the way, we will quiz your understanding. Before we go further, please note that this presentation is for educational purposes only and does not constitute legal advice. Immigration laws and policies can change rapidly, and outcomes depend on specific facts. For personalized guidance, consult a qualified immigration attorney. Next, let's set the context. Administrative actions, new regulations, or executive policies can slow or even pause naturalization processing for large groups. Often, applicants are still permitted to file, but adjudication is delayed or frozen, creating uncertainty and disruption. Now let's clarify a crucial distinction. Filing refers to submitting your N-400 application. Adjudication refers to the government's review and decision-making. In many policy shifts, filing remains open while adjudication slows or pauses. A freeze can halt background checks, interviews, or final decisions. This affects timelines for family reunification, employment opportunities, security clearance-dependent roles, and the ability to vote once naturalized. The key insight is that filing keeps your place in line, but adjudication is where a freeze has its real effect. Here is your first quiz. The question is, if a policy freeze is announced, can most eligible lawful permanent residents still submit the N-400 application? The options are A. No, filing stops immediately. B. Yes, filing usually remains open, but decisions may be delayed. C. Only first-time filers can submit. D. Only those with military service can submit. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Filing generally remains possible, but adjudication may be paused or delayed by agency policy. This flowchart illustrates what happens after filing. The normal path includes intake, background checks, interview, and decision. When a freeze is in effect, the case can be placed on hold. At that point, one path is to wait until the policy changes. Another path is to seek legal intervention, such as filing a writ-of-mandamus, which asks a federal court to compel the agency to adjudicate within a reasonable time. If the court orders action or the government resolves the case during litigation, the process returns to a decision stage. Moving on. Legal recourse often takes the form of a writ of mandamus. This is a federal court action that seeks to compel the agency to perform its duty and adjudicate within a reasonable time frame. Courts frequently view sweeping bans affecting established permanent residents with skepticism, especially if the policies appear to exceed agency authority or infringe due process rights. While litigation is complex, costly, and rarely fast, it can resolve prolonged stalemates. Experienced immigration litigators evaluate timing, the appropriate court, evidentiary support, and the likelihood of success. This sequence diagram shows the flow of a mandamus case. The applicant retains an attorney, who files a petition in federal court. The Department of Justice appears on behalf of USCIS. The court sets response deadlines. Several outcomes are possible. USCIS may adjudicate during the pendency of the case. The court may order the agency to act by a certain date, or the case may be dismissed as moot if action occurs. Throughout, the central legal concept is whether the agency has unreasonably delayed action. Now, let's compare options. Waiting can be less costly and less stressful up front, and policies sometimes lift without intervention. However, waiting involves uncertainty, potential lost opportunities, and the risk that the policy persists. Litigation can accelerate adjudication, bring court scrutiny to broad bans, and create accountability, but it introduces legal costs, coordination time, and no guaranteed outcome. The right choice depends on personal priorities, urgency, and risk tolerance. Before pursuing any step, ensure eligibility is clear. Continuous residence, physical presence, and good moral character are central requirements. Documentation should include the green card, tax transcripts, travel records, and relationship evidence when applicable. Proper documentation strengthens filing and any subsequent litigation. Here is a practical sequence. First, file a complete and well-documented N-400 and keep meticulous records. Next, build a timeline of all case events. If your history is complex, consider requesting your file through FOIA. Then, consult an experienced immigration litigator early to evaluate venue and timing. Prepare evidence of harm from delay, such as lost job opportunities or impacts on family. Finally, decide whether to wait for a policy change or proceed with a mandamus action. If you litigate, coordinate declarations and exhibits carefully. Here is your second quiz. The question is, what does a writ of mandamus primarily seek in the context of a naturalization freeze? The options are A. Automatic approval of citizenship, B. Monetary damages for delay, C. A court order compelling the agency to adjudicate within a reasonable time, and D. A waiver of eligibility requirements. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. A writ of mandamus is designed to compel the agency to adjudicate within a reasonable time. It does not guarantee approval, award damages, or waive eligibility requirements. Furthermore, consider costs such as attorney fees and court expenses. Timelines depend on court schedules, though agencies frequently act before a final ruling. Outcomes include compelled decisions, cases becoming moot after agency action, or policy changes that alter the litigation posture. While adverse precedent in delay suits is uncommon, there are no guarantees. Keep expectations clear. Litigation is primarily a tool to prompt adjudication, not to alter eligibility criteria. This timeline highlights a typical progression. After filing the N-400, a policy freeze may be announced. There can be months of inactivity. At that point, you might consult a litigator and file a mandamus action. The Department of Justice responds, and sometimes the agency adjudicates before the court rules. A status conference may occur, followed by either a court order or a mootness dismissal if adjudication has occurred. If approved, the process culminates in the oath ceremony. All timeframes vary. Now here are key terms and quick notes. Naturalization via the N-400 is the application to become a citizen. Adjudication is the agency's review and decision process. A policy freeze is an administrative pause that delays processing. A writ of mandamus is a lawsuit seeking to compel action, not automatic approval. Maintain a checklist that includes proof of eligibility, documentation of harm from delay, and notes from attorney consultations. Also, keep a dated case log to document every milestone. As we synthesize, remember these core points. Filing often remains available, but adjudication is where freezes occur. Courts tend to scrutinize blanket delays affecting established permanent residents. A mandamus suit can compel action, but it does not guarantee approval. Act early, by documenting eligibility and consulting experienced counsel. Finally, make a strategic choice between waiting and litigating, based on your risk tolerance and urgency. To recap, policy shifts often interrupt the path to citizenship primarily at the adjudication stage. Freezes may stall thousands of cases, even if filing remains possible. Legal intervention through mandamus can move stalled cases. The best advice is to file correctly, document thoroughly, and consult litigation counsel early. Stay realistic about costs, timelines, and potential outcomes. Thank you for watching. If you found this helpful, please like the video, share it with someone who may benefit, and subscribe for more content. Tell us your experiences or questions in the comments so we can address them in future videos.